I think one of the great pleasures of being a lawyer in our field is that we are surrounded by younger people who come up with good ideas and are prepared to battle. Paul has it with a lot of his interns that he's bringing that help him with his cases. Even my own son has gone and been working with him for the last few weeks. But I see it with my own team. I've got a fantastic team of 50 or 60 lawyers in Leigh who are absolutely in there to make sure that whatever the hurdles are put up in front of us by the multinationals, by government, by the courts, that we get round them. And that's our job. It's not to say, in the way that Richard Meeran was talking about earlier, that hurdles will always be put up in front of us, whether that's getting rid of legal aid or whether it's this Rome 2 provision, which means that we can only claim foreign damages rather than the British damages for people. There will always be challenges, but our job is not to worry about that, but is to get around them, to get over them. And I have absolutely no doubt that Paul and his team will be getting over the current debacle that was the Kiobel judgment. Now, I wanted to talk a bit about the British scene. I was going to take on a bit of a wide exposition, but because of the time, I'll perhaps narrow it down a bit more. We've got two big cases that are coming to trial in the next few months, and I thought it worthwhile just spelling a bit out about those two cases, partly because I think that certainly one of them is very likely to go through trial, maybe both. And so, first of all, as you see things appearing in the media, you'll have perhaps a bit more of a context about them. And secondly, in terms of understanding some of the issues that they raise, it will hopefully be of interest. The first case that comes to trial is we are suing BP in relation to a pipeline that was taken through, that goes through Colombia, brings out oil from central Colombia and takes it off to the northwest coast where it's refined. Now, the pipeline that takes the oil was constructed in the mid-1990s, and this was a massive construction. This is going through some massively mountainous areas of Colombia, and it's one of the most wet areas of the world. So the problem has been that in the construction, the claimants say, in the construction of the pipeline, in the digging out of all the ground to lay the pipeline, this caused massive damage to a lot of the farms along the way, in the silting up of the streams of the farms, so that the productivity of the farms is dramatically diminished, say the claimants. The defence case, BP's case, is no. Despite this massive construction that took place, it actually isn't anything to do with that construction. It is all caused by things like the cows that walk along the area. That they've caused all this massive disruption to the farms and people walking along themselves along what became the right-of-way, where the pipeline was constructed. The other things, lots of other things have caused all these difficulties that the farmers only by some amazing chance started to complain about after the BP pipeline was built, erected. But no, they said nothing to do with them whatsoever, blame the cows. Now, what was interesting about the case was firstly in terms of the relations that one sees between big multinationals like BP and local communities, is that the community complained like mad very shortly after the pipeline was erected. There was massive complaints from lots of local communities. They'd employed a local lawyer to try and resolve the case for them, didn't get anywhere. It was only when they actually came over here to London and started to complain at the AGMs of BP that they started to be taken at all seriously. We were brought into the action mid-2000s, about 8 or 9 years ago, and we were able to successfully settle the first 35 cases. But when a next group of farmers came along saying, look, we've just heard these cases have been settled, could you also act for us and take our case on the same basis? It's clear that BP have dug their heels in and are likely to fight it through to the end. Now, the case is due to go to start on the 1st of October, and it's been listed for 5 months, which is a long time to be in trial. The expert evidence runs, I was being told by the team the other day, runs to something like 20,000 pages of expert evidence on the two sides. There are 28 experts that are going to be giving evidence between the two sides. And the costs of the whole case between the two sides are going to be around something like 35 to 40 million pounds. Now, that's quite a lot of money. The claims are worth a fraction of that. But it is an indication in the way that Richard was describing earlier how hard defendants will fight when they think that there is an issue of principle about their reputation to be made. And as Richard was saying, the kind of big worry is as we get into this whole debate about proportionality, that those sorts of costs, well, BP will still spend the 20 to 25 million pounds that they're planning to spend. They will still spend that. But we will not be able to. We will not be able to spend a fraction of that, because in the end, if the damages end up only, say, 5 or 10 million, then the high chances in the future under the existing regime, that is all the cost that we would be allowed to get. So if we've spent costs of 15 to 20 million ourselves to match the defendants, we'd be absolutely knackered. We'd be out of business within 5 seconds. So the difficulty is that imbalance between the resources at the disposal of the defendants, who don't really care how much it costs, because there's a point for them of principle that they don't want it to be seen that they're an easy target for some campesinos in Colombia. So they will spend all that money when, if they'd sat around the table with the farmers back in the 1990s when this all happened, it could easily have been resolved for a minute fraction of the sums that they're now looking at. The same position is rather true in Shell, as Paul's been saying that they sued Shell in relation to the Curable case, and indeed Ken Saro-Wiwa before that, back over the last 10, 20 years. We have brought a case against Shell in relation to their operations of a massive oil leak that took place in a small town called Bodo in the Niger Delta. Now, the leaks took place in 2008. We say there were hundreds of thousands of barrels of oil that were released, and that they've ended up polluting something like 100 square kilometres, which is the main creek which this community have fished in for decades, if not centuries. Now, when the leak was first established, it took weeks and weeks before Shell were able to get round to fixing the pipe, so the oil was pouring out into the local community for all that time, and it has destroyed the mangroves which suffuse the creek, which is a fabulous area for fishing, and has meant that effectively that the people of the community have not been able to fish for the last 6 years. Now they've been scratching around trying to keep going. We're in the process at the moment of taking statements from many of them, and it's just the most terrible, terrible situation where some of the women are being forced into prostitution, some of the men have to travel are away from their families for months at a time. So this community that was absolutely thriving, had a lovely lifestyle, lived in a really beautiful part of Nigeria, is now decimated by what has happened. And what has Shell done? Well, when they first happened, they sent round something like 10 bags of flour and rice for the community. The community insisted that they came in to try and reach some resolution. So before they had any lawyers in, Shell came and gave them the magnificent offer of £4,000 for the whole community for this 100 square kilometres of land that they had totally damaged. They then turned and said, well, actually, the damage is only a very small fraction of that. It's only 30 hectares of damage because our engineers were out there and that's what they saw. And we said, well, explain to us how it works then. So here is an area where every 12 hours, because it's right on the Atlantic coast, the tide comes into the creek. The areas that are dry for half the day are then underwater for the other half of the day. So the tide comes in, tide comes out. Tide comes in, tide comes out. It goes massively fast, so it's travelling at quite a lick. And it kind of goes for about 10, 15 kilometres inland and then comes back out. And what they were saying is that their engineers, when they were trying to estimate what the size of the leak is, they go to the leak and they say, well, how much oil can I see? Oh, well, I can see, there's probably about 200 metres of oil in a bit of a circle. And then you kind of measure the depth. Well, it's that thick. And then you multiply the two together and you get the volume of oil that Shell say was spilled. But I'm saying, well, I don't quite understand that, because the tide's just, all you'd be seeing is that the oil that was there for the last 12 hours, because the tide will have washed it all away. Oh, that's a good point. Now, this is traditionally what Shell has done all the time in terms of measuring how much oil had been released in these spills. They have had to accept that now their initial calculation was absolute nonsense, and that the amount of oil is massively more than they ever first suggested. But the idea that a multinational company like Shell, who announce all the time how much oil has been released in these spills, that they had such a Mickey Mouse way of actually calculating how much oil, rather than having any sort of process that tells you exactly how much oil is released from the pipeline, this ridiculous way. But it was just indicative of the poverty of the process in terms of their analysis of the damage that is being caused in these communities. Now, since we got instructed, we had a meeting with Shell shortly after we'd been instructed, where they increased that offer from £4,000 to £1 million. And then about a year ago, they increased that offer again to £18 million. Now, none of that is enough, but it's a bit better than the £4,000 that they were prepared to sit round the table with the local community. So when Mr. John Ruggie, that famous man, produced his third pillar that Robert and his team were reviewing, and said, well, look, we should have more mediations, we should have more sitting round with the local communities. I rather fell out with him about 18 months ago when we were at a conference in Amsterdam. Well, I said, John, you've got the wrong end of the stick, mate. The pillar should say, sue, sue, and sue again. Because to be frank, that is what these companies understand. It is only when you have a court hearing, whether it's going to be a jury in the States or hopefully a decent judge in the UK, that is what they understand. That is when they come to the negotiating table with sensible figures, when they are forced into having to disclose documents to show exactly what they've been doing. If you just allow them, again in the way that Richard was describing in terms of what happens in Tanzania and elsewhere, when they have these local schemes, they take massive advantage from the fact that the local communities do not have the resources to bring in lawyers, that they do not have the resources to bring in experts. They use the position in every possible way. Their absolute role is to make money. All these policies that they produce are absolutely worthless when it comes to on the ground doing what they do, which is to make money. So, me and my team of 60, and hopefully Paul and his team in the States, we will continue to do our job, which sue the bastards.